So I am Bridget Fahey, and I'm a professor here at the University of Chicago Law School. And I'll briefly introduce our panelists and then begin with some questions. Rick Hills is a professor at NYU Law School. Alison LaCroix is a professor and legal historian at the University of Chicago. Richard Primus is a professor at the University of Michigan. And Judith Resnik is a professor at Yale Law School. Now, I'm not saying very much about the august panel because this group of scholars is among the most prolific group of writers about questions of federalism, and I want to save the broad balance of our time for that discussion. And it's a perfect group for this kind of perspectives panel because the idea is we want to have a conversation that can engage both the future work that the panelists are drafting and thinking about, but also the past important work that we are still talking about. So Alison and Richard both wrote influential books about federalism published in the last year. Judith and Rick are among constantly producing new work about federalism, so hopefully we'll be able to engage this broad body. The other important thing about this panel, besides the fact that two panelists chose to wear clothing with maps on it, which tells you something about their deep love of federalism and its geographical elements, is this is a group of scholars that does not propound federalism orthodoxies. They each have articulated influential and unorthodox views about federalism. So I especially want to ask the panel, when you're describing your views or engaging in conversation, to maybe explain what you are in conversation with, which is some of the things that our students will have been taught in Con Law 1, or we will read in Supreme Court opinions. Okay, so to begin, I want to just ask the panel to talk about what is American federalism, which is a deceptively simple question, and I suspect that what you will hear will not always reflect what you have read in casebooks or Supreme Court opinions, and that there will be some real disagreement. So I'll start with Richard.
Okay.
Since you're ready.
Thank you, Bridget. Can I just say it's a privilege to do this with Judith, who was one of my first teachers of federalism, and Rick, who is my first co-author on any federalism paper that I co-authored because he and I disagreed about everything and therefore wrote a paper together. And Alison, who's been like my contemporary along the way, figuring out these things since we were law students in the same classroom, and who is now the convocation speaker. Yeah, like that's an honor. Like most things in con law, vast oversimplification, but that's all we have time for, right? Oversimplification. Like most things in con law, federalism is fundamentally about two things. It's about governance, right? And it's about national identity. And when we have conflicts over important things in federalism, frequently both of those things are in play at the same time, right? More or less acknowledged. In the sandbox where I play, we would, instead of governance and national identity, we would say structure and ethos, right, as like modalities of constitutional interpretation. Those are the two big things in play. I'm a structure guy, by which I mean not that ethos isn't interesting and not that it isn't powerful, but we really need to get the garbage picked up. And the Constitution and the legal order fails if it doesn't do that in reasonable ways. And so the struggle for people who practice federalism, I think, properly conceived, is to prevent the contest about national identity, which is affecting how people think about federalism in all kinds of ways, from getting in the way of sensible decision-making about governance. Right? That's like the basic combat terrain of federalism as I see it. And the obstacles, briefly, are these, right? First, that the national identity thing is actually really, really powerful, right? And second, that the machinery of federalism that we have, the raw materials, are actually quite badly built as a governance mechanism, right? And I mean that in two ways, and I'll say what they are and then I'll stop. The first is the Supreme Court, and commentators sometimes like to talk about the carefully crafted balance of power between the states and the national government. And every time I read that phrase, I think, boy, a lot of cultural work has gone into persuading ourselves of that, right? Because I think it's just fundamentally unsupportable. right? Whatever allocation of powers there was at the beginning is like haphazard rather than carefully crafted. And even if it were carefully crafted, it wasn't beta tested, right? Um, uh, and through trial and error, we've worked out a bunch of reasonably sensible arrangements since then. But in a trial and error, feeling our way through kind of way, right? And the basic units of play, the states, like no system designer who wanted either to come up with a system where the subunits would be good for governance, nor who wanted to map cultural communities or communities of interest would come up with anything like the map of states that we have. I'm happy to defend that proposition at length, right? But I think it's just really true. I mean, in what system would you have California, Texas, and Nebraska, right? We think in shorthands sometimes about the states as cultural units because California, Texas, and Nebraska are all different. But like Texas is like 6 different political cultures. So we have raw materials that are not conducive to the thing that we're trying to do with them. And I think that set of problems is a lot of the motor that drives federalism and makes it both interesting and fraught.
Great. Judith, do you want to go next?
Sure. One of the pleasures of teaching is seeing other people thrive and grow up and thrive more. So I'm enjoying enormously. Thank you. So the class I teach is called now Federal and State Courts in the Federal System. I thought I could actually, as I told my students, call it just unsettled, or I could call it, and actually today I think I could call it unnerved as well. So a question about the it of it. I mean, when you say, right now, the question of the stability and the coherence of the thing called states. I mean, we want to start at the state side for a moment, but I'm going to do it through, there's a guy named Jean-Luc Goheno who wrote a book called The English title is The End of the Nation State. And in it, he says, had a great run from the Enlightenment, solved a lot of problems, territory was coherent, and organization could flow as well as good norms around rights and structure, if you want to do it that way, along the way. And it's ended because of acid rain. At the time, the book is doesn't use the verbiage of climate change, but he was arguing about problems were still acute at the local level. Can I walk outside on the street and be safe? And will there be light and heat and air? And then there's the global or the trans, but it's certainly not going to be working at the nation state level. And then what do we do to generate some of the things that some of us admire about what Enlightenment nation states brought to bear? So a question is for me right now, is the question of a coherence of the thing called states. So one is a descriptive account with great historians here of, Alison will tell us about regions and remapping. There's actually, you remind me of Joe Singer has a map of the Indian tribes as superimposed on the state, how do you think about the landmass of the United States? So regions is kind of an easy thing. Translocal organizations of government actors thinking about the ways they cooperate together. So a model of state, which equal footing question for Rick will be state versus state, or state as a unit of analysis when states co-venture, states conflict. There's a whole lot of questions about how to think about this. And then if we talk about things called blue and red and purple maybe, then the drivers of state identity are clearly weakening. Larry Kramer has a terrific paper from decades ago about how political parties, not mentioned in the Constitution, indeed anxiously worried about, generate state identity. And then, of course, all of us know the question of the grip of the political parties. So, and of course, we who sit court-centric a lot will think about the way of court doctrine, Murdoch or Erie, making the coherence, insisting on some level of state law autonomy. And so, and there are many of us here will pool ideas about what are the drivers of state identity, and does it have resilience? And then Richard just said, and there are five states in Texas in terms of, 5 different cultures. So the question is, if we think it's good, and I know teed up on our questions will be what are the normative or social, moral, political utilities of federalism, so I won't go there yet. And Alison and I both pluralize it, federalisms. But when we get there, one is, can the it endure given campaign financing and technology? What are the things that we would want in place that would generate interactions to insist on a set of coherent mappings of a thing called states or states together or regions? So next one up.
Thank you. So, I mean, this is a rich and complicated question, obviously. One thing, I think when we teach why federalism today in structural con law, for instance, the three reasons that I think the court has given over the years that I usually give that I think are some reasons. One is this idea of state sovereignty or state autonomy, some interesting sort of backing away from the use of sovereignty at different points, and then the court kind of reclaims that in the 1980s. But if we're uncomfortable with sovereignty or we just think it's hard to define it, it's autonomy. So that's reason one. Reason two is accountability. We hear this a lot from the court in the anti-commandeering cases, in lots of cases about how does the citizen know who to blame, who to praise if they like a policy. And then three, individual liberty. This notion of federalism protects the liberty of the individual, which I think kind of came into the cases in a sort of resounding way in the late 90s, early 2000s, but has been theorized by many over the years, including, I would say, Robert Cover's article from the 70s, I think, Jurisdictional Redundancy, where he makes a version of that argument that isn't as much about accountability. So those are sort of reasons. But I think we could also say, well, assume we have a system that says our system, for one reason or another, thinks or protects the states from being used as the agents of the federal government. I think one of the interesting things about this right now, and especially for me as a historian who's been working on the 18th century and now the 19th century, is the way that our vision today of federalism is so dependent on a sort of Reconstruction and 20th century view of the alignments of the states and the federal government. Or people say federalism is a nothing, it's an empty shell, it's a fig leaf, all sorts of metaphors, a lot of food metaphors, interestingly, in this realm. But it's just the opportunistic argument of whoever doesn't control the center, all of a sudden they discover local power and, great. But there's a more sinister version of what federalism arguments are about. And that argument says, well, federalism, or to put it even more strongly, states' rights, those arguments are not just fig leaves, they are covers for pernicious views. So pro-slavery being a big one, or pro-Jim Crow, or anti-federal power in the sort of 1930s, 1940s. And so there's almost this assumption that states' rights, again, to put it in that, I think, tendentious but maximal view, is always an argument that is only made by sort of the anti sort of certain versions of liberty, or a conservative argument or a reactionary argument. And so this is interesting today because I think there's this, the number of articles that we've all read or probably, spoken to reporters about liberals discover states' rights, right? And should liberals and progressives be sort of angsting about this because aren't these the enemy's tools? And but the fact is they may be the enemy's tools, but the enemy has always been there, and the enemy is on all sides. So if we look at the 19th century before the Civil War and Reconstruction, states' rights arguments made by anti-slavery states, by states like Wisconsin, Massachusetts, Pennsylvania, fighting the federal government being the enforcer of the Fugitive Slave Acts. That's very surprising. That's not our traditional narrative. And so I think it's interesting that we even need to, as scholars, sort of remind people of that story, which isn't to say states' rights are necessarily one way or the other, state power is necessarily one way or the other, but the unsettled nature of this relationship has been there. And I know it's the historian thing to say, oh, it's complicated, but I'm not doing that because I think that is in fact our system, that there is this back and forth and that there is some reality there, which I think Bridget and I for years have been sort of saying like federalism is real, and sometimes that has seemed like, oh, what's wrong with you that you think the states are real? Putting that a little bluntly, maybe. And I think, no, the tension and the jurisdictional redundancy, multiplicity, those are the system, and we are stuck fighting about it. And so it isn't one side or the other's to claim.
So it's great to be here, but I think I only play one role in this, is to pick fights with people. So I'm going to be very simple. I think federalism, constitutional federalism, has historically been about reducing ethnocultural conflict to save the national political process from polarization. Issues like banking, slavery, alcohol, and church schools in the 19th century were compromised through the rhetoric of federalism, because federalism became a method by which national political parties could get political cover for not resolving these issues. And in that sense, it was extremely important for holding the country together. I think Stephen Skoranik's new book, which says the country's falling apart because we can no longer compromise on these polarizing issues, is an indication of why the federalism's historic purpose now being eroded has been critical. Here's the second thing I would say about federalism. The constitutional text, the written text of the enumeration, is useless for performing this critical function that federalism actually performs. The enumeration implies that Congress's powers are special and states are residual. The reality is states' exclusive powers are special and Congress's powers are residual. So we use terms like traditional state concerns or sensitive state concerns as a signal to say states actually have these enumerated exclusive powers, but nothing in the text will tell us what they are. Chief Justice Roberts will suggest it has something to do with crime or violent crime, or maybe education or marriage or schools. And he's simply echoing exactly what the 19th century constantly said. States have special powers over, for instance, banking. The most important federalism case in the antebellum period is Bank of Augusta, because it's when Chief Justice Taney said the states have powers over letters of credit that the National Bank does not, thus giving the power of the states to hold the Democratic Party together. Because the Democratic Party was viciously divided between pro-bankers and anti-bankers, and this gave a way for each state to go its own way. Likewise, in the fight over the mini blames, the big fight was, what do we do about Catholic schools? And the Republican Party felt driven to say, we need a national rule on Catholic schools. And federalism became a brilliant way to say, no, just leave it to the states. And they defeat the national Blaine Amendment, but let all the states, if they want, adopt mini blames. And in these moments, federalism saved the country from collapse, because the parties would have split apart entirely had they not had the political cover of being able to say, oh, the state should handle that. Nothing in the text helped them do that. There is no special reserved states clause, because states' powers are supposed to be residual. And we're suffering with that now, because it's an extremely difficult collective action problem for a national political party to say, here's an issue that some of your base really care about. I don't know, let's say abortion. If we take a position on that, we'll lose the suburbs in Ohio. So we want you, even though you care passionately about abortion, to say it's for the states to decide. The fact that Trump could do that is a tribute to the fact that the Republican Party is an appendage of Trump. That's a classic 19th century move. It's clearly saved the Republican Party to the extent that it can be saved. Like, this was, as far as the abortion issue is concerned, it was clearly the best policy for the Republican Party for Trump to play the role of Stephen Douglas on abortion. But it's almost impossible for any other party to do that. So for instance, obviously on Title IX, the Democratic Party is hurt very much by the Office of Civil Rights in the Department of Education taking aggressive positions on how to enforce Title IX. Can the Democratic Party win the moderator to the debates? Can the candidates say, oh, we think the states should decide, when they say, when you come back into power, are you going to push some policy on sexual harassment, to reverse the Trump policies? They'll all have to say yes. They can't say no, let the states decide. The raw materials are there. Title IX has a pinpoint provision that would allow them to back off. They can't. Because of the collective action problem, they got to get past the primary. The collective action problem afflicts both the parties and Congress itself. So I think the critical question is whether we can revive this idea of federalism as a way of reducing ethnocultural division. By ethnocultural, I mean identitarian divisions that are too hot for the national political process to handle. I'm cautiously pessimistic, but I'm open to arguments that we can do it. Oh, hello.
Okay, so maybe I will attempt a little bit of a summary and then ask a follow-up set of questions. So one thing that I think we've heard, which should be no surprise to anyone who's read the modern federalism, that kind of academic literature, is that federalism does not seem to be a kind of fixed allocation of power, that we just have to tease through the text of the Constitution and find what powers have been enumerated to the federal government and all the rest are reserved for the states, and they sort of govern on these separate parallel tracks independently. Rather, we see, I think, accounts from across the panel of federalism being a system and being kind of much more integrated and renegotiable than the constitutional text might suggest. I also hear from the panelists that to think of federalism as a purely kind of partisan allocation of powers, in which we imagine the federal government as the progressive blue entity and the states as the red entity, or that is kind of characteristic of these states' rights conversations, is also wrong. It sounds like federalism in the views of the panel is something more varied and dynamic, and I wanted to ask some questions about what the law is of this more dynamic system. And in particular, so when I was in law school a decade ago, my recollection is that there was no love lost for the Rehnquist Court's federalism jurisprudence, for the anti-commandeering rule and the Commerce Clause cases for National League of Cities and so on. And so, maybe that's why I have been defending the anti-commandeering rule since law school, just because, like Rick, I like to be a contrarian. So I wanted to ask the panel to just think about federalism doctrine and either pick a doctrine that you think is right, is helpful, is supporting the our system of federalism, or obviously it's acceptable to have the view that the doctrine is irrelevant and none of it's helping. Is legal doctrine scaffolding our federalist system, or is it irrelevant?
Well, legal doctrine can have political side effects. And so, for instance, I think the idea that we're going to modify the necessary and proper clause with the great substantial and independent powers idea that Roberts pushed in Sibelius and then pushed in a concurrence in Kebido could be useful, but it mostly will be useful in the halls of Congress. I don't think there's going to be a lot of Supreme Court opinions, but if he can just insert more language in there, it could provide enough political cover for people in Congress to say, oh, we really shouldn't push this issue because that's a great substantial independent power. Totally non-textual, by the way. It has the same relationship to the necessary and proper clause as the doctrine of fundamental rights in Griswold has to the 14th Amendment. It's just something where you carve out a non-textual exception and say, these are special. I love that. That's great. And it could have knock-on political partisan effects, even though I doubt there's going to be a bunch of precedents striking down federal statutes that deal with, say, crime or guns or abortion. I mean, it would be nice to have a bunch of precedents that did that, but basically, if you need the court to do that, the system has failed.
Well, I think I would say something about teaching this to answer this question, which is I teach structural con law 1 here, and I think 3 years ago, I did something that I'd been thinking about for a while, but had always felt sort of worried about, which is to start teaching Prigg versus Pennsylvania with the anti-commandeering cases. So Prigg is from 1842. You have to go to another part of the casebook to find it because it is a bad case. It is anti-canonical in lots of ways, to use Jamal Green's formulation. It's the Supreme Court upholding the Federal Fugitive Slave Act of 1850, nationalizing slavery, saying this supposedly local institution that we've sort of agreed politically exists in states, sort of along Rick's views, is actually national. And so Mississippi or Virginia gets to reach out from the state and pull back people who are alleged to be fugitives or just are people who someone shows up in that other state and says, this person is a fugitive slave. And they can get the whole architecture of the federal government, act of Congress behind them, and commissioners and executive branch officials. So the court upholds this. Justice Story writes the opinion. So this is one of these interesting cases of someone who's from Massachusetts, supposedly anti-slavery, probably actually anti-slavery in some way, but is also a nationalist. It's the same term as Swift versus Tyson, if you want to think about sort of story cases that are about uniformity and national power. And Story is reviled across the North, especially as the slave catcher in chief. That, we sort of expect this 15 years later from Chief Justice Taney and Dred Scott, but Story does this. And so why bring that in? Because even in this case where Story says, contra the arguments of really excellent lawyers like Salmon P. Chase, who was a terrific lawyer, and many others who had made the argument that the Fugitive Slave Clause of the Constitution is not a power of Congress. It's not mandatory. It's in Article 4, which is sort of compacty and talks about the Union. Chase had said that. Instead, the court says, no, this is an enumerated power of Congress, and Congress must legislate to enable the right of recaption, as it was called. But the one thing that even there, Story, the slave catcher in chief nationalizer with the court behind him, says is that state officials cannot be required to carry out federal law. So the sheriff of Middlesex County or Milwaukee County or Cuyahoga County cannot be compelled to do this. If the federal government wants to have this structure of recapture or kidnapping people and taking them out of state, it's going to have to do it through federal power, federal commissioners, et cetera, which is what Congress then does in the Fugitive Slave Act of 1850. So this is about the Fugitive Slave Act of 1793. I think I called it 1850 earlier. So Congress later does that because of what Story says. So why bring this into discussion today in a con law class? Well, A, delicately. B, I think because it says, okay, that's a different constitutional regime, I think. I think we can all, pretty much at least take as a possibility that the pre-Civil War era is different in lots and lots of ways, maybe go all the way to Eric Foner's idea of the of Civil War and Reconstruction as a second founding. But even there, where the whole system is committed to slavery, they say you can't compel state officials to do this. There are these pockets of state and local power that the federal government cannot use. So that lines up to me with a case like Prince from 1997, even though the court doesn't cite these earlier cases, to say this is a deep principle that even when the court was politically and legally motivated to expand federal power, it had to say you can't compel local and state officials. So in a perverse way, it actually shows the durability of that principle, even in that sort of early period one, sort of pre-Civil War period. So I think it's helpful. And then it adds a sort of, how do we think about that history? How do we think about principles coming out of those cases? But I think it helps ground some of the 20th century doctrine.
I teach Prig as a commandeering case, right? I think it's really useful in those ways. And there's a quick comment on Rick, though there's actually a lot in what he says here that I agree with. I have a very hard time imagining the great power gloss on the necessary and proper clause effectively prompting or enabling members of Congress to do the thing that Rick wants them to do with it, because the members, like, if you think about the way the members of Congress behave and what their incentives are and so forth, right? Apply what you apply about the Democrats running in the primary, you're going to have, right? So like it might be nice, but I doubt that salvation will come from that quarter. I will say more about commandeering. I think the early commandeering cases, New York and Prince, I love those cases as teaching tools, and I love them as constitutional interpretation cases because I think the cases are genuinely difficult. I think the issues presented as of the years when they were presented were genuinely difficult issues, and I think that there are a lot of moves made in the opinions in the cases that just strike me as really lousy as a matter of constitutional interpretation, and therefore that makes them great teaching tools, and also is an occasion for thinking about, well, why is this so hard, right? What else? What's happening here? I always had the view from that they were hard questions, and I spent a bunch of years sort of agnostic, both agnostic and sort of not caring about what the right answer was. I was just more interested like in the fact of the question and so on. But then came to the view that, though I still think they're hard questions in constitutional interpretation, right? Once you discount the value of the normative power of the actual, right? We've lived with them for a quarter of a century, so they don't seem as hard anymore. But I've come to the view that I'm happy that the cases exist and come out the way they do, because there is a really set of powerful impulses in the system to do things that protect states as autonomous decision makers, and for some good reasons. And that impulse is either going to be gratified procedurally or substantively. And the attempt to do it substantively is sort of hopeless. They say that it's the problem with dual federalism, right? The attempt to draw the line in a world where any given thing that people actually do can be classified in a bunch of different ways, right? Like, is this roadside lighting project, right, local policy or national policy, and how would we decide? And then multiply that by everything else. The attempt to articulate substantive limits, right, we all know the story, like, doesn't go very well. Maybe we could design a system that was more explicit about the residual state powers that should be held that way. Canada has a slightly more sophisticated way than we do of doing it. They articulate state powers, but that still puts them in a position of having to fight a lot, right, about what actually, who gets to do what. So it's fine with me for the Supreme Court, certainly. Legislators and administrators should think a lot in practical ways about the question, does it make sense to do this at this national level rather than at some local level, right? I think that's super important, and the answer should often be, no, this should be done at the local level. I think it's really hard for courts to think about that in useful ways, right, for reasons that a lot of us have been through. But procedurally, I think it's not as hard to do. I think to say there are certain aspects of the procedural ways in which the national and state or local governments work together that we're going to say, no, you can't do that because we want to preserve some degree of autonomous decision making locally, and that requires a bunch of things, including some amount of procedural autonomy, I think makes sense. I mean, I think the fundamental things are the local decision makers have to be selected by a process that's independent of the national government, and they have to be able to budget independently, right? I think those two things are non-negotiable. After that, you could build a machine in lots of different ways, and I'm not saying that this way with these anti-commandeering rules is the only or necessarily even the optimal way to do it, but it's one way to do it, and it serves a useful function. I think there are things that happen in anti-commandeering doctrine afterwards, like I can make very little sense of Murphy versus NCAA. I don't understand it. Or worse yet, maybe I do. But the basic rules, right, and the basic idea that there should be those rules makes a certain amount of sense because of the work that it does to make the state governments autonomous decision makers in at least some way where I think the project of trying to do that by reserving substantive domains of policymaking to them is a non-starter, right? But this is not.
So to just reiterate the question of what work can legal doctrine do to generate state, one version is disaggregating states. So there's the state courts, the state prosecutors, state legislatures. So if we start at the court, obviously pillars are autonomy in making a thing called state law when we decide it is state law. So you're back at, well, in Erie, and of course right now we're in an era where the general law folks are shooting at Erie. So, if we want to make the doctrine can say we have a unified system, so we get a whole case, we'll think about everything, and we'll tell you, Tennessee, what we have to say, and you can take it for what it's worth. Doctrine can say there's more autonomy. There's two footnotes in terms of the, one is obvious, well, one footnote is there's a current swell of anti-Erie, of different versions of puzzles about Erie, which by the way, I think is a common law doctrine. So here we are with that. But notice there's a case this term on your, what I will call the dash docket, in which I get an email out of the blue from a state state justice saying, what did the Supreme Court just do? They took the New York case about voting without it even going to the New York Court of Appeals. Whoa, what happened to state autonomy? He says to me on this email. So the question of the court's loyalty, and there's, as I think about it, there's nobody, you prompted us with the Rehnquist, we identify Rehnquist, O'Connor, Powell as hugging states. There's nobody currently on the court. There are people who, Justice Sotomayor was our state prosecutor. Obviously, Justice Gorsuch tribes as having a sense of the subunits or units and integrity and identity. We got a couple, but as a sort of jurisprudential matter, a deep commitment to states in that full throttled way from state roles of longer duration. We don't have people on that now. So one, like, just flag, what's the dash docket doing, having anything to do with states, which they hardly have anything to do with anyway in terms of the US Supreme Court's own docket. The other, just to note, there's a funky little case about the New Jersey Transit, about state immunity, whether as a New Jersey Transit buses harmed people in both New York and in Pennsylvania. And then the question was, can they sue? And are they the state, so they're immune, or are they an arm of the state? And the state said, well, that's up to us. And the Supreme Court says it's a matter of federal law whether you're an arm of the state or the state's a real party in interest. So we can drill into doctrine saying, when is it? There's just these odd little windows. So Proposition 1, state courts. Proposition 2, which is more mixed, which comes back to actually a few of these comments of federalism is normatively committed to disagreement and conflict. And it is a mediating device, whether you do various of the different ways to do mediation around it. And so I sometimes talk about federalism discounts and accommodations. And in the moment, you're trying to and let's do habeas, Lee's here, unreasonably wrong. A federal statute that says that state courts can't just be wrong, federal courts change the outcome in a criminal habeas petition and a civil habeas petition challenging a criminal conviction unless there is not just wrong on federal law, but unreasonably wrong. And I always analogize it to the margin of appreciation doctrine in the European courts, which is to say, we're discounting. So we're going to live in a plural system where there's more than one intellectually liberal ideas of more than one right answer in a non-totalitarian sense. And as a consequence, we're going to discount and mediate so doctrine can do that. And then the question about whether we valorized it or we don't like it and when we are cheerful and when we're not in terms of the substance, which gets, and so that goes to a mixture of prosecution in some instances and courts. Legislation, we should be talking about preemption. Because preemption, the willingness to read narrow federal preemption as a huge engine of dislocation of state legislative authority that is hard to capture kind of in the aggregate because it's always drill into that statute or drill into this one. But when one looks at it broader brush, and then you ask about it as federal executive power preemption, the Crosby kinds of cases, Garamendi, these issues about whether there can be, whether states can do things transnationally like ban forced labor or the like Crosby. The question about federal preemption and whether it takes executive action, legislative action with what clarity and what's the field is another area that if you're looking at doctrine, it's really important. If you want a cheerful take, as you could then say, we're in the middle of federalism loves conflict, feeds on conflict, dialogical engagement, and it is the way to develop both national identity, the idea that it's an ex-ante identity versus in the context of whether abortion is local or national is a debate about what it means to understand rights-bearing, gender, reproduction, freedom, and the like, the same way guns, whatever, pick your topic. So the cheerful is, it's a way to mediate not just not just deep disagreements on substantive areas where maybe there's, in some instances where there's, some are clear, there's right answers, and in some areas that are not, and of course the real challenge is where do you tolerate and when is it that you have to say this is intolerable behavior to be part of this polity.
I'll maybe ask two more questions, then we'll save some time for questions from the room. So, one of the themes that I heard articulated is various ways of thinking about federalism as a system that can accommodate pluralism, can facilitate negotiation, can enable mediation. And of course, you have to ask the question that Judith just asked at the end, which is sometimes we don't want pluralism or accommodation or mediation. Sometimes we want a national standard, and those are difficult questions. But as a form of government designed to facilitate some degree of pluralism and negotiation and mediation and maybe dynamism, changes in how we structure governance that over time rather than kind of fixed constitutional rules. Can I ask the panel to grade federalism against these rubrics? Are we doing well? Are we doing better? There is a view of structural constitutional law in the air at this moment, which is that a lot is fragile and brittle. Can you just assess federalism's success, and then also identify whether there are legal or academic questions that we in the room should be thinking about to be able to better answer that question, maybe descriptively, or to be able to better advance our system, strengthen our system of federalism by exploring. Maybe I'll start, I'll reverse us and go back to Judith first, if that's okay.
One version is, what are the hot topics? So commandeering was this little example, and now I don't know how many cases I can teach with the name gnome, and keep any of them straight for any of us. So I was just actually thinking about another facet of the suck resources out of states or give resources. So I think a vector that we've talked, so one of the Minnesota cases, a district court judge says, the argument from Minneapolis was that you're taking our policing resources through your surge, and this is a form of commandeering. And the district court judge said, well, kind of not. There was equal footing arguments and there were commandeering arguments in a long opinion that said, yeah, I see both sides. The end of it kind of says, if I do this, the Eighth Circuit won't let me. If you isn't quite as bold as that, or bald, but it does seem to say that. So one question is, one model that I push against is this, there's federal and there's state and they're different. In terms of over the 20th century and 21st century now, a lot of shared projects. The National Center for State Courts had some monograph that said there are more than 100 statutes that tell states to do X, Y, or Z as part of implementing federal law. So the question about resource sharing, resource capacity, how do you shore it up? And looking at this question about courts, the question, so capital investment, federal capital investment in state courts is remarkably little. The State Justice Institute gets something under $13 million a year for sharing grants to do something. And state courts are direct service delivery entities in which 80% of the people lack lawyers in one or the other side of the case, if not both. And in which judges, hard-pressed public servants, have caseload dockets in far excess of federal courts. So one example of a place, since a little court-centric is, of sharing resources would be to say, how can the federal government enable states through resource infusion that can make their court systems more able to provide the services? And what's the political economy against that is obviously not all people are enthusiastic about rights claiming as some other sets of people. But what are the services states provide, back to my opening comment, the need for the local, and what are the ways in which, in theories around both doctrine, what are the ways that stand in the way of more sharing, of more of an image of joint venturing, of less of a discourse of interference in terms of, Bob Cover and Alex Alenkoff wrote Dialogical Federalism around this habeas interaction. What are the ways to inspire more joint? There's a spate of, I don't know how much state federal councils or state federal tribal councils are running now. There's a period in the 80s and 90s when judges sat together, came together at conferences with some regularity, and then there's actually literally sitting together in some cases, like in asbestos in Ray Brooklyn shipyards or something, where the federal and state judge sat next to each other and jointly ventured. So the question of thinking through it as a joint venture seems to me something that we should be looking, and if we're worried about fragility, the discourse of conflict misses, isn't it Aaron Delaney has a piece called Solidarity Federalism? What are the ways we can increase an understanding of codependency? Any of you who are involved in Supreme Court nominations, polling data, nobody knows the name of any of those people, but they do know the name of people who are called judge and are on TV.
If I get nothing more valuable out of this conference than Rick's formula, cautious pessimism, it will have been worth the day. What I have to say about this, I think, is in that vein, right? If you think of the law-politics divide, and like not in a naive way that doesn't work, but in a more sophisticated way where there's like a large gray area, but it's still helpful, useful to think about the difference sometimes. I think that we are in a moment where law does not have a lot to contribute to making federalism work or work better or continue to work. That's a shame. I like law, but I think it's a reality. I think there are a bunch of things about the constitutional system that are now like, there's a big dike and it's sprung a lot of leaks, and more all the time, and it's moving very fast. The attempt to think about, well, like, what is the problem and how can we fix this is overtaken by events over and over again. And I think that the idea of like a system that reaches stability in a pretty functional way is at this point over the event horizon. That doesn't mean we'll never get there, right? It just means that we can't really see it from here. We don't know how long it is from here to there. I think that that's more so at a faster pace right now with separation of powers, checks and balances issues than with federalism issues, right? Because of the nature of the present dumpster fire. But it's true in federalism also. And I think that we are fortunate that there is enough that is functional about federalism that it does like damage mitigation right now. And but the thing about damage mitigation is it doesn't reverse the damage, right? And there's a hole in the dike, and then there's another hole in the dike. I think that means that attention to the sorts of practical dynamics that Judith talked about are super important as a way of understanding what in the architecture of this thing is actually functional, could be actually functional, right? So that when the politics of the constitutional system come to a point where it's possible to do a rebuilding, it can be done thoughtfully with attention to a lot of those practical, like institutional arrangements and structural dynamics, rather than through the attempt to like restore at a large conceptual level somebody's idea of how the system used to work, which will only be somebody's imagined view, and probably not really how the system used to work anyway. Which means I think that it's a time for thinking on the politics side, or if you prefer, on the constitution making side of the equation, and to think about that like in view of the realities of like what makes it difficult to do, right? 300 million people is a lot of people, and all of those other things, and also in view of like the practical institutional arrangements that could go well or badly, which actually requires a ton of actual expertise to think about. but you can't get lost in that expertise thinking about it now, because because one of the things about thinking with that kind of expertise, as important as it is it's a bunch of small bore problems that exist when the ecosystem is configured a particular way. And the chance that the ecosystem will be configured in that particular way, such that this particular solution will be responsive when we reach the event horizon, are small for any of those particular problems. But I still think we need to think about them all the time, right? General Eisenhower said, "Believe in planning and not in plans." And I think that's the attitude that I'm trying to articulate.
I would throw another characterization phrase, sort of seeming paradox in, which is to say, I guess on this question of what has federalism done for us lately, I'm a kind of optimistic pessimist, which is to say, I think one defense of federalism for a long time that people I made, and it sometimes was hard to get traction on, was to say, imagine it's Europe in the 1930s. Would you rather there be more or fewer jurisdictions with different rules, right? And different regimes and governments and legal orders. And so is that federalism protects the liberty of the individual? Maybe, but it's also just a sort of, that's the pessimism is because it relies on an idea that some national level force might be harmful or negatively consequential or just really bad, right? So you'd rather hedge against that possibility by having the sort of exit right, I guess, which is as economical as I'm going to sound. So it's another way of saying also the friction is the point and the sort of states as the safeguards of the republic. What do I think is not what has it not done well, or what are we still sort of working in progress on? This is something I'm thinking about a lot now because I'm working on a book project on the Civil War and Reconstruction. When you finish a book that ends in 1861, it sort of invites a sequel, a renewal of the season, so to speak. So hopefully that's happening. But the coercion point, like actual coercion by the center of the periphery, we don't have great answers about that. So here's Madison. If we look for great answers, we should look to Madison at least for something. So this is in the Constitutional Convention. The Virginians in the Virginia Plan come in, and they have a grant of power in their plan, giving Congress the power to call forth the force of the Union against any member of the Union failing to fulfill its duty under the articles thereof. Madison, as the kind of leader of the Virginia delegation through the course of the convention, pulls back on this. He says, it's probably not the best way to proceed. He writes himself telling the convention, so he maybe said this to the convention, a union of the states containing such an ingredient seemed to provide for its own destruction. The use of force against a state would look more like a declaration of war than an infliction of punishment, and would probably be considered by the party attacked as a dissolution of all previous compacts by which it might be bound. The New Jersey plan, interestingly, which usually is the sort of decentralizing plan against the Virginians, the New Jersey plan went even further toward consolidation and coercion, so that's kind of interesting to think about. But how do we think about that sort of in terms of constitutional time? I think Lincoln thought a lot about this, and that was part of the position, which was to say, right, we, the Union, are not using the force against a state as a declaration of war. It's the state came to us with its war, and we are bound to respond to it in the form it presented, which is the court in the prize cases ruling on the blockade. But I think we don't have a good theory of coercion. We have examples of coercion, and then we have sort of the Civil War as this contra-example that doesn't fit in, and yet clearly has framed how we think about this. So I think that's really one of the deep questions that we're living with right now.
So the question was, as a form of pluralism encouragement, is federalism doing well? So we have to give it a grade. It depends what you mean by federalism, but I say C+. C+, I'm passing. On doctrine, terribly. I liked Bond, and I think that soft constitutional law, substantive limits, I always wonder why people say, well, we couldn't have federalism substantive limits. I think, well, in the 14th Amendment, we have substantive limits. Mirabelli and Yoder, et cetera, we say, well, family and education are fundamental rights. But we can't do that with virtually identical analysis of the necessary and proper clause. Well, why not? If Griswold provides a substantive limit on state power based upon some judge-made category, why couldn't you do the same thing with the necessary and proper clause? Why isn't it exactly analogous? Now, maybe Griswold's a failure too, but the court seems to want to push the pedal on that with Mirabelli. So on doctrine, I'm not so sure it's done well. On statutes, there's a lot of obscure statutory provisions that are doing a lot of work now. I would like to plug the Westfall Act, 1988 Federalism decision. So ICE officers now are discovering that the absolute immunity promised to them by Christy Nome is not exactly as much as it adds up to, because the Westfall Act, of course, says that state law will govern vicarious liability. Right, and so I just from Colorado, an ICE officer is discovering that Colorado has really lousy law on vicarious liability. The employer is liable for nothing, and so they're all acting out of scope of employment. Likewise, the Westfall Act has a lovely little exception saying it was supposed to preserve Bivens probably, but it says this absolute immunity that we're conferring on federal officers doesn't apply to constitutional causes of action. And now we see that a lot of states are enacting state causes of action, so-called Converse 1983. Why, just the other day, somebody sued under Maine's cause of action, ICE officers. Well, that's entirely the result of statutory federalism of the Westfall Act. The chickens are coming home to roost. It turns out that state law has a lot of power to control federal officers, despite the disaster of the second holding of McCulloch and Tarbell's case and Abelman versus Booth, all of which I look on as more or less catastrophic. But it's nice to know that Congress is cleaning up the court's mess. So statutory, B plus, A minus, depending upon whether I take class participation into account. Doctrine, C plus.
Okay, all right, very good.
Can I throw in one
Yes.
small practical note on this thing that Rick had said? If any of you is in touch with people in the state legislatures who are working on or drafting these state level 1983s, I want to make one suggestion. Better than Converse 1983 is universal 1983. That is to say, a statute that creates the same substantive liability, but doesn't single out the feds. It's duplicative of the existing 1983, but it's also less likely to get struck down, right, as an easy gimme in federal court later.
And to add an attorney fee shifting provision to it, because state litigators need to have the resources to do it. I just wanted to flag the question of coercion. Sounds more polite than the violence that we're talking about. And I think it's important in terms of your emerging issues and federalism, resiliency, and Alison's sad reference to the 1930s, that physical violence by federal agencies, which is what Rick was just discussing, and in terms of sort of edge. So the POCA, Protect Our Courts Act. I didn't think POCA wasn't, I wouldn't have necessarily made that association before a couple of years ago, but this idea that people could be safe inside courts from fugitive slave grabbing by federal agents is one of the ways, and is a place of specific example of the questions that Bridget's great commandeering paper and others are raising about what role of physical force, and Richard's suggestion that state law can provide remedies for state force, and revisit Tarbell. Can I get injunctions or mandamus against the physical force you're about to inflict upon me? So if you want the sort of, I don't know where you put it on your spectrum of cautious and optimistic, pessimistic, but I think to not talk about actual violence against individuals, and the individuals in Minneapolis who tried to buffer physically against the violence that others were experiencing, is an important thing for the classroom to take into account, because there's a way in which we could be abstracting the not practical but visceral interaction in the thing called the United States and federalism.
Okay, so just to take the prerogative to echo the idea that understanding the practical dynamics of how federalism actually works on the ground, I think there is an endless scope of topics to be explored there and expertise to be developed. So for any students in the room who want to be law professors, I don't think you can go wrong by doing just that. And then also to say this conversation about the federalism of coercive force, the federalism of policing, of prosecution, of the militia clause, the National Guard. They have been on the front page of the newspaper for the last year, and there isn't a broad federalism literature or a broad modern federalism doctrine on these questions, which is why Rick is picking a fight with McCullough versus Maryland. So there again, for any students in the room who are inspired to study federalism, that is a set of topics. I was going to ask the panel for their views on some of those questions, but I would rather open the conversation to the floor. So you can ask those questions if you want, but we'll start with Will.
So I'm very interested in the questions about doctrine and whether doctrine matters, whether doctrine can do anything, and also the various pluralism questions. So my favorite federalism doctrines are conflict of laws, which of course have now been shunted off to their own course. And a weird thing about conflict of laws is that it has a ton of doctrine, which is very complicated. And the doctrine is largely not in the hands of the Supreme Court. It's largely shaped by some mix of state courts who sometimes understand what they're doing and sometimes have no idea what they're doing, and a few law professors with the help of the American Law Institute. And there's much debate about that's gone well or badly. But I guess this makes me wonder, it's obviously important. It's central to slavery. It's central to prohibition. It's central now to fights over abortion. Is it or is it not the case that Louisiana can call a New York doctor to account for sending something to Louisiana and so on? Would conflict of laws doctrine be improved if the Supreme Court got involved? Would it be better if the Supreme Court enforced some basic ground rules, or should we think whatever you think about conflicts, the Supreme Court's involvement will make it worse?
Well, just one quick, first of all, Joe Singer has a terrific article walking through 90 pages of the interstice of state, federal on abortion providers and others, just to flag. But second, there's a case called GM versus General Motors versus Baker versus General Motors. The couple times the Supreme Court has gotten into the thing called conflicts, it said, I don't know what to do, like almost literally. And the Baker case is, can a Michigan settlement agreement keep somebody from testifying when cars are exploding and he's an engineer who knows about the explosion? And what is this does this travel? Is it a judgment? How do we think about it? So I would just want to first say, we don't think, we maybe in academic circles don't write and talk enough about what full faith and credit does mean. But one of the reasons that we collectively are somewhat stymied is when it comes to those questions, we're back at the same questions we were just debating. What's the trump? What is it that I can stand? What is the entry point in being a state that means that when the state says, no, this will never be a marriage, I have to respect that everywhere or not? So it's not, yes, it's there. How it illuminates is a real, at least in the past, it hasn't been a font of Supreme Court capacity to illuminate. And if you like the idea of distribution, you want to keep them quiet so that the states justices can be in an engaged, serious conversation about how to think through these interactions.
Just on that point, I don't know, need a mic. Can the Supreme Court, or at least the federal courts, not get involved if you have a fight over perfecting judgments?
I just will be left.
So imagine if say New York or California does not enforce a Texas judgment on SB 8, as they obviously won't, and they're going to say the penal law exception to enforcements of judgments. Can the U.S. Supreme Court not get involved? And the answer is yes, the Supreme Court cannot get involved. Now, of course, that means that one side's going to win this fight, right? And I think the people up here will think the good guys will win. Well, I mean, if New York and California can protect their abortion providers, in that case, Judith, you'll think the good guys won, I think, right? And so to the extent that, now I could see the bad guys winning if, for instance, Louisiana says, fine, we won't enforce your judgments against gun manufacturers or pumping guns into New York. So that would be, I think one of the practical questions to ask is whether they could just sit this one out and let the final forum win, which will be the forum that won't enforce judgments. And I think they could, and I wonder if they will, and would that make the system better? Tough question that. I think that probably it's going to be a very one-sided victory on the question of abortion for abortion's rights if they don't get involved. And I think Justice Kavanaugh would be happy with that.
So one thing that I think a lot of people have been thinking about, the panel only kind of lightly touched on during the last year, is whether we ought to think about federalism, at least today, as one of the guardrails against a slide to authoritarianism, particularly if Congress is kind of AWOL from the picture. And it briefly touched on about things like the Westfall Act of 1983, which I think my own guess is those are not going to go super far, or at least I wouldn't put a lot of money on those. But things like the structure providing a locus of contestation from popular governors and others, that clearly has been an issue. It seems like the last year where it's easier places to push back, and if they're popular, particularly have units of loyalty they can associate with resistance. Some things like default control over elections and things like that seems like a very big deal right now, and is actually a little bit hardwired even into the Constitution. And people on Trump's camp seem to want to push against it, but that's a sign that it probably is doing something. The pardon power doesn't work for criminal prosecutions at the state level. It seems like a limit. It's also built-in limits the pardon power by definition. So even that collection, I'm probably leaving a bunch of things out. Should we, regardless of its flaws, view the fact that we have a federal structure as a kind of a helpful thing at a time in which we live, in which this is more of a danger maybe than it's been in the past?
So yes, but a helpful thing and a solution are two different things, right? It's damage mitigation, right? Alison, this example of the 1930s, right, is an instantiation of like the old-fashioned Federalists' gamble, right? And so there's insurance in like I'll focus on elections, right? Because like until you mentioned it, I was thinking, is he going to say elections, right? The allocation of control over elections to federal office in the first instance, and often in the last instance to state officials, is a kind of portfolio diversification, right? And like useful for all the same reasons, right? I think it's critically important, right? Here are two things to notice about it. One, it is not the face of federalism that is about governing autonomously, right, in ways that are responsive to local policy choices, right, a local community, right, that wishes to be governed differently from some other community. It's about influencing the national community, right? That's the work that it's doing, and that's actually like super important diversification work, right? That's the first thing. The second thing is, of the various things that you mentioned, it's actually probably the one that as a formal matter is the most vulnerable to federal takeover, right? Because Congress has an enumerated power, right, by which it could just wipe all that out. There's a tendency in judicial opinions about the Elections Clause to write as if that clause were a much stronger assignment textually of the authority over these elections to the states than it is. You could say that reflects a small c constitutional commitment to something different from what the untutored reader of the big C Constitution would say. But the thing about living through a moment like the one we're living through now is that small c constitutional understandings can disappear quickly, right? And I think that one is actually particularly vulnerable. And its disappearance would be like an 11-alarm fire.
I'll just add, I think picking up on something you said, Kurt, the kind of cultural rallying point and the fact that which is a function that states can powerfully serve, and they are not only a group, a movement. I mean, they get the benefit of being states and governments. And so to have there be an organized focal point that is, in many cases, either resistance explicitly or implicitly, but that is a focal point that is a legally constructed entity, I think is enormously appealing and is actually a hopeful story that people, sort of nation of government of law is not men, etc., that it's like very powerful to people, which is, also ties into local affiliations and sort of community or like local control. But the number of times we heard references to Minnesota, right, it wasn't about other groups or other entities. And I think that's very powerful. And, you walk around any sort of Civil War battlefield, and the monuments are to the Union. Some way they're the Union Army, but they are organized by state, right? So and that's a different era. But I think the focal point that is actually a government tells us a lot that actually, Americans kind of like government, and they kind of like states. So I think that's telling us something.
I did one little thing to say, which is I think the critical issue here is nationalization of elections and whether the state politicians will feel that they have enough of a separate brand identity. I call this the Mike DeWine complex, that they can push back against the national political parties. Obviously, Congress is not doing the Federalist 51 ambition countering ambition. It might be that governors in particular have a separate brand. And they may dig in their heels because they just don't like losing power. And you do see that a little bit with Republican governors. I call it the secret intergovernmental stuff, right? Jessica Bowman Posen writes nicely about this intergovernmental stuff. And they do dig in their heels. And it might very well be that because they have a separate brand, they don't have to worry too much about the primary challenge. Obviously, Brian Kemp in Georgia is Exhibit A.
Just very briefly, I want to do something that I do with great trepidation, which is maybe to disagree with Alison. I think that I agree that it's significant that people talk about Minnesota. And I agree that as a structural matter, the fact that Minnesota exists as a going concern with a lot of people on its payroll, who know how to do, super important. But I think that there are two different senses of Minnesota in this in this thought, right? One is the org chart and the payroll and all those things that are the government. And the other is the idea of Minnesota as a social and identitarian construct, right? There is a tendency in the federalism literature to think people identify with states. It's meaningful to talk about the states. And therefore, that has implications for things about policymaking and so on and so forth. And I think that last step is often a non sequitur, right? So I identify subjectively with both Indiana, which is the state of my childhood, and Michigan, which is the state of my adult life, right? But I don't think that any part of my identification with either of those things runs through policy set in Indianapolis or Lansing, right? I mean, the first part runs through Hoosiers, right? And right, right, and mutatis mutandis for all the other things, and you can replicate this for your own states, right? The fact that we have those identifications is something that people who run state governments can leverage to try and do the various things that might be useful or, when we're less lucky, destructive, right, in the federal system, right? But I think it's useful to keep our eye on the fact that they are two separate things.
Okay, I just want to say one thing about the political process, which is to observe that the conventional way of talking about federalism's political process is to think of senators and congressmen representing state interests in the institution of Congress or delegates to the Electoral College in selecting the president. But the conversation today has focused on many other different political processes and ways that the federal government engages with the states or the states engage with each other. And they're different actors. They're governors or they're police officers or they are state court judges who are engaging with federal law in different ways. So there's also the chance to think about federalism's political process in a much broader lens as maybe being some of part of the source of its resilience. But we will leave that further conversation to another time, and I'll thank the panelists for a lively conversation.